Welcome to War Story Wednesdays. Today I want to talk about a topic that is near and dear to every broker's heart, and that's how do you get paid? Let us step back in time, 1992.
In my state, when people lose their jobs, there's a good chance I'll know them by their names.
So if you're scared, if you haven't got the stomach for this, let's get it out right now.
You've got a client that is looking to buy some commercial property, and you show them property after property after property, and finally, they make an offer. $4 million piece of property. The commission on this one, you're doing the math in your head, it's going to be $100,000. You've probably already spent it way before the deal gets closed. In fact, this deal never closes. The buyer, for no reason, no stated reason, simply decides not to go forward with the deal and breaches the contract. Now there's a $20,000 deposit that was put up, and the seller wants that 20 grand as part of the liquidated damages provision. You're thinking, how can I get part of the 20 grand? Or wait a minute, how can I get my 100 grand deposit? The buyer refuses to sign cancellation instructions, and so the seller has to file suit. And the seller sues the buyer, oh, by the way, and the real estate broker, the buyer's real estate broker. That's adding insult to injury. The case marches forward, and the seller wins and gets the $20,000 as liquidated damages. The buyer appeals and loses. The real estate broker was dismissed in the claim by the seller, but keeps the claim against the buyer for the $100,000 commission. Now, according to the terms of the purchase agreement, the seller is supposed to pay the real estate commission from the proceeds of the sale, right, that are being paid by the buyer, and the broker for the buyer was hired by the buyer. So it's not a dual agency. When the real estate broker, the buyer's broker, sues the buyer tries to defend against the claim by saying the deal didn't close, so there's no commission due from the seller. Well, that didn't work because it was the buyer who breached the deal. So then the buyer says, but wait, according to the listing agreement itself, it says that if the buyer breaches the contract, the seller is only responsible to pay the real estate broker 50% of the amount of the money that the seller actually collects from the buyer, up to the maximum amount of the commission. And since the seller only got 20 grand, the buyer said that the most that the broker can get is $10,000, half of the 20 grand. And the trial court agreed. And don't you know, the broker appealed and said, this doesn't seem right. And the Court of Appeal agreed with the broker and said, you're right, you get $100,000. And the buyer is screaming bloody murder. How come? How come? The listing agreement says that in the event of a default by the buyer, and that's me, and I'll even agree that I defaulted under the purchase agreement, that the most the broker can get is half of the amount that the seller collected. And the seller only got 20, that's 10. What's the problem? And here's what the Court of Appeal said. The listing agreement says that the broker can get from the seller half of what the seller collects. But the listing agreement doesn't say anything about what the broker can get from the buyer. And in this case, because the buyer interfered with the transaction between the buyer and the seller, which caused the broker to lose the full $100,000 commission, that's the amount that the broker was entitled to receive. The court said that it's much like the broker was a third-party beneficiary under the purchase agreement between the buyer and the seller. And as a result, it was intended for the broker to collect a full 100 grand on the commission. And when the buyer breached that agreement, the buyer inherited the obligation to pay the broker the full amount that the broker would otherwise have received. Not a bad day's work for the real estate brokerage.